enter some pleas in the motion, and then what about the new case?
New case is pleaded not true, and if there's administrative things, we can go through that.
Seems like execution.
I think the victim did a non-prosecution. Or is it attempted?
I'm not saying no. I'm not ready to say that.
Computers.
This is not my case, I'm just standing in for,
Ms. Malfino.
Yes, yes, for this, so I can't speak to what she intends to do with the case.
I'm sorry, my screen is still loading. There. Is everybody's spinning? Oh,
I don't see the motion for a bond.
Should-
We'd ask for 3 days, I'm not prepared to go forward on that, for that advance notice.
Should have requested one in the letter, if not the motion itself, on the notice letter.
request for probation bond and speedy hearing
Revocation hearing, yes, sir.
was filed August 18th. Let me just go through this motion
It's
first.
the same one always filed.
Mr. You're Nathan Lamel? Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So I'm just gonna go through it.
All right, Mr. Lamel, in cause number 24 DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true? You weren't arrested?
Well, he was arrested. but-
That's what the allegation is, and I'm not, anyway, y'all, I don't know why they've changed them to just arrested, because being arrested isn't really a violation instead of committing the offense. All of a sudden, all these motions are different. Y'all might want to take a look at that. They're not alleging that they committed the offense.
I
So-
apologize, Your Honor. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count 1, you're pleading true to? Okay.
You were arrested.
Count 2 alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count 2 is either. Now, just don't worry about it, because it doesn't say what it was, and so I don't think that is an accurate, I don't think I can go forward on count 2. Count 3 alleges that you failed to report to the probation office March 5th and April 9th of 2025, and is that true or not true? Count 3 is true. Count 4,
Just to be clear, I think what he said was it's true that he called in, so I don't know that he was.
did you
clear.
report or did you not report on March 5th or April 9th?
I'm not sure.
I think what he said was you didn't report, but you called in.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
We'll plead not true. I think he's not sure.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? That's marijuana, THC. Did you test positive on May 1st? Speak up.
I'm not sure.
Okay.
Not true.
Count 5 alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of 2025, and is that true or not true? Count 6 alleges that you tested positive on May 1st of 2025 for alcohol, and is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those 2 counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence,
I think you pled not true, not to 5.
1 and 5?
That's my understanding.
He
That's what I
pled,
wrote down.
he pled. he
No,
pled
5 is 3:01 a.m. I thought he
He said
said,
not true.
Not true,
I wrote down not true.
oh, I'm sorry.
He's only
So,
played true to number 1.
right.
okay, so you're saying that is not true that you were at a location other than your residence at 3 o'clock in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
Oh, that was my reason.
He's saying it was his residence that he was
That's what I
arrested
was
at,
saying.
what he was saying. So it's not true.
Okay, count 1 then. All right, so I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
Yes, ma'am.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct?
but there's a non-prosecution file for that.
That's-
so
I
that
don't-
may be
that's-
part of it.
All right, so, we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit in cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. I printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean? or-
Yeah, any evidence with regard to your request for a bond?
Well, just that he's on, I believe he's on deferred, and, what's your financial situation right now? Not too good, you employed, or did you lose your job because of the arrest?
I had a job, but I lost the job for the rest. I had
Where were
quit.
you working?
I don't. I had just started. Doing that.
I can't, if I,
Speak up.
don't make
I
me
had
tell you to
just
speak up
started, it wasn't
again.
that long.
I would just say he doesn't appear to be an absconder, Your Honor, and they're just a few days. It seemed to be.
Well, my issue, I mean, regardless, I guess at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, Your Honor.
well, he had already been trespassed, warned by the officer, I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a window that was broken and coming through a window, so that doesn't.
She knows she's not prosecution. I don't know if she is. I think the victim, the alleged victim's present, Your Honor, if you wanna recognize
I
him.
renew the state's position that we weren't prepared to go forward. In fact, on the bond today, in fact, there's a copy of that letter that Mr. Kimler references. You may have a copy there, but I don't have a copy filed. We asked for at least a couple of days to
Did you
be adequately prepared.
did you just send that to us, or did you e-file it?
It was
And
e-filed, I don't know if she
and did-
tagged, I mean, I don't do my.
you gotta make
e-file.
sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present though.
And
Your
we're not
Honor, if I
prepared to go
wanna-
forward.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the motion that's been filed.
Well, it was
It wasn't a motion.
a
No, there is a motion.
letter.
There's a motion filed.
We have neither a motion or a letter in the file.
Well, that's their problem, Your Honor. I mean, that's not mine. He's in jail. And, I mean,
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not, don't,
But it was e-files. My point is it's on file with the clerk. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she doesn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there. Yeah, I guess when you do need to make sure, I guess I have it from the 18th, a request for reasonable probation bond and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
She has filed a non-prosecution.
You have that in the file? Okay.
And one final thing I'll say on this is, it's one thing to e-file something, but it's a whole nother thing to make sure that you hit the tab or,
I've gotten there too. I've already
initiate
said,
the service.
I understand, and that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly,
To Ashley. I mean, you can see on the e-file notification.
that it was sent to her.
To Ashley.
Okay, so it was sent. Is Miss Malfino upstairs?
Yes, ma'am.
All right, let's get her down here real quick, please. All right, are you Shadamon Mitchell? And will your client waive the formal reading of the indictment?
She will.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes, ma'am.
Okay, I'm
We're okay with it.
inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today since y'all have the restitution amount?
Judge, doesn't have a criminal.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes.
So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months. And all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation, and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again.
I'm sorry.
I don't need to see your belly button in court.
Oh, yes, ma'am.
Okay? You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way. And dressing like that is not an adult way to show up to court. Okay? You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay? Good luck to you, ma'am. Thank you. Good morning, sir. You're Kendrick Walker? And this is 24 DCCR 0196. Mr. Walker was previously in court, entered a plea of guilty to unlawful possession of a firearm by a felon. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We haven't.
Yes, Your Honor, I have.
Any additions or corrections?
There is one that we would like to bring to light, Judge. We spoke quite a bit this weekend. On the defendant's version, there was a little bit of an inaccuracy. Mr. Walker had specified that when he was in the vehicle, he did not put the firearm in the vehicle, but he did learn that there was a firearm in the car, and realizes that he should have gotten out of the vehicle and left at that point.
Okay.
So that was kind of, it was a little unclear with that. So we wanted to just clarify that part.
So I also want you to understand, Mr. Walker, the opportunity that you're being given today, you've already had a felony probation that was revoked, and it wasn't that long ago. So the fact that you're getting a probation in this case is a real gift, and so if you want to make sure you understand that you need to follow all of the rules. If you're back in here, it's not going to be on a revocation or because you didn't do it, oh, give me another chance. This is your other chance, okay? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made. Find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. Obviously, if you do that, again, this is a great opportunity because you're going to be able to serve that 10-year sentence while you're out on probation. The other side, though, if you're back in here, you've already agreed to a 10-year sentence. And so please make sure you follow all of those rules. I'm going to hand you the trial court certification that shows, Mr. Nichols, that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this at this point, but I am required to read this by law. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. And again, as you can tell, it doesn't even have to be yours to be in possession of it. You can't be in a car with a gun, in a house with a gun, anything like that, okay? All right, have a seat here in the courtroom. Probation will call you up when they're ready to go over your paperwork.
Thank you, Your Honor.
Thank you, Mr. Rennick. Mr. Franklin, you have Ray No.
Yes, Your Honor.
He said, how are you doing?
Hi, I'm
Good morning, you're Kevin Ross.
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24 DCCR 1198 on probation for the offense of a deadly weapon in a penal institution, and in 24-1199, evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just
Yeah, go ahead.
inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requests of the trooper and we just have not brought it in. It's a June 13th date.
And if I
Can't
may
imagine
add,
why it would
Judge, I
be.
will represent to the court, I do have an affidavit from another individual, but I need the video, because we could really shortchange, get right to the point.
Who's the trooper?
And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations,
I'm sorry, Judge.
and so,
Garcia. Jordan Garcia.
I'm sorry.
I had Jordan Garcia, I had St. Joseph's at North Oklahoma.
In addition, Your Honor, the Magistrate Court,
Yeah,
in my motion, I also add, if you were to consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer and told her she understands the situation.
so we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m. Okay.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So,
And I'll
but
have Mr. Bates reach out as well, Judge.
Okay.
This morning while you're on the bench.
Okay.
They can get,
if you'll let them,
when they know the court is.
if Detective Bates will let them know that he's going to call them or I'm going to call them, so maybe they can get that very quickly, and we'll go from there. All right, go back with the bailiff. I'll at the discovery certification.
I don't have it because I didn't expect to plead it. I will email it immediately.
Did you sign the?
Oh, I can see that far.
Well, I need we need it today because if I'm going to sentence her, the case gets closed out and you won't be able to get it.
I'll email the judge too.
I'm gonna,
Okay.
as soon as I get to my computer, which is
No,
next door.
I'll email.
Okay, either way, yeah, just do it before she does the judgment because once that happens, I think the portal closes. All right, ma'am, you're Michelle Johnston. And Mr. West, will your client waive the formal reading of the
She
indictment?
will, Your Honor. Thank you.
And so we're going forward today with sentencing and everything?
Yes, Your Honor, we're going forward, we're asking the court to give her credit for the time that she served, the 15 months on the federal sentence, which was, the time that she served was during the pendency of this case. In fact, at this time, I'd offer State's Exhibit number 1.
2.
No,
Make it number 2, please.
Which is information related to her
federal sentence.
federal sentence. And for the record, she was indicted in the federal case in October of 2023 And then this case came along, October, she was pled and sentenced in the federal case in October of 2024, and this case had been pending, having been indicted in December of 2023.
So
no
she started, does that have any objection to that?
No objection, no objection.
So that sentence there was for a 15-month sentence.
Yes, Your Honor.
And so it's y'all's intention that I give her that entire 15 months and that she not be required to go do any,
That's
Yes,
the intent of the parties, Judge.
that's what we want, Your Honor, yes.
I guess the issue becomes on these, because it was a federal sentence, that she has not technically been to and received a number from TDC, which is required in this case. And so but you don't have one on this case.
But when Jefferson County came and picked me up from feds and brought me to 69, and I was over there overnight until I got the bond the next day. So they gave me a number.
That's a
She
jail
has a
number.
So you have
TRN.
Oh.
She has a TRN.
But she doesn't have a TDC.
Right. No, she's not been to TC.
Yeah, because I've never been to TDC.
I don't think I can just give credit and her not go through. I can give her the credit,
Right.
but she's gonna have to go in and get a TDC number. It's my understanding. So let's do this. Obviously, if you have credit, we're not gonna make you go anywhere today. So just,
She's working through it.
I understand what y'all are trying to do, and I'm not in disagreement with that. But legally, I have to make sure
Okay.
that we do it in the right way, because if you don't have a TDC number, I don't think we can do it that way. The only thing that we could do on a state jail felony, if you want to give her, why don't y'all just do a 1244?
I'm okay with that, Judge.
That clears it all up,
I obviously don't have a problem with that, Your Honor.
because then she doesn't need,
She has an TDC number.
she's doing her jail, her time in our county jail.
She has enough credit for that.
I'm looking at y'all like y'all are gonna help me figure this out.
I'm okay with it.
I think that makes it cleaner, because she doesn't necessarily,
I'm okay with that, Your Honor.
Yeah.
I mean, it's the same result. Everybody
yeah,
wants
yeah.
credit,
Right. It's still getting the conviction.
but it's still a state jail felony conviction, so she still needs a state, I'm thinking all this through, because she still needs a state.
And if need be, I'm okay with proceeding on lesser included.
That honestly
misdemeanor
makes
theft.
it the most clean.
Just do a misdemeanor theft,
12
sentence
months.
her to 12 months,
Yeah.
give her credit for the.
That
federal
helps,
time.
I think that makes it,
So we can get on down the road, Judge.
As far as
Okay, I
convictions
appreciate
go,
that,
she has a
Mr.
federal
Coleman.
conviction. That's the
so
most
let me,
stigma.
hold on a second, let me get this, indictment, and we're gonna go through all, I'm gonna recall everything that I just did. We're gonna kind of start over a little bit. You're good. This
You're
this
good.
makes it where you're going home and it's all taken care of, okay?
That's what we're trying to do, is there's some legalities that we have problems with, that she understands what we all want to do here. So
When
she's
you
making
get
it work.
sentenced to state jail or TDC, you have to have a state jail or TDC number. You gotta kind of go through that process and then get right back out,
let's go.
but it's not necessarily a quick process always. So this is gonna be, with everyone's permission, can I make the modifications on the agreed punishment recommendations as well as the admonishments as to what we're doing?
No objection from the state.
No objection from us, Your Honor.
So I'm going to change this. If I could figure it out. Okay, so let's go back. And in 23 DCCR 2260, the state is elected to proceed on the lesser included offense of a Class A misdemeanor theft from November 14th of 2020. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. West?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And what we've all worked through here is that the punishment would be for a 12-month term in the Jefferson County Jail. You will receive credit on that sentence for all of that time because you were in custody in,
From May.
hold on. Cause number, no, that's not it.
One.
Where is it?
24-CR-32, Judge.
Thank you, Mr. Coleman. And that was a 15-month sentence in the federal system. And so I am giving you credit for all 12 months on this sentence. Is that everyone's understanding?
Yes, Your Honor.
Yes,
Please.
Judge.
State tenders number 1,
No objection?
it's admitted. Also, I'm going to admit number 2 without objection.
No objection also.
All right. Is there any evidence that Ms. Johnson is not
Oh,
competent?
no, not, no, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the Class A misdemeanor of theft. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail. Again, you receive credit on that sentence for all of the time that you were in custody on that federal case. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You should be printing soon.
Here's the.
Here's states. Who gets that? Do they get states too? Okay. Oh. I get that. You get that. Okay, thank you, ma'am. You're free to go.
Thank you.
Thank you, Mr. West. Thank you, Mr. Coleman, for helping work that out.